Today, in this brief video, I'm going to take a little bit of time to talk to you about private land use restrictions that come in the form of real covenants and equitable servitudes. In essence, these are private agreements that regulate two or more parcels of land, and usually the overall or overarching purpose and goal of these private agreements is to increase the total value of all parcels of real estate involved. These are private agreements that receive judicial recognition. If someone breaches or violates the agreement, you can turn to the courts and enforce the agreement against the violator, whether that be an original promisor or an original promisee or their successors in interest if they've sold the property. Usually, but not always, the effect is to burden the use of one parcel of land for the benefit of another parcel of land. But this isn't always the case. Sometimes benefits and burdens can be mutual or reciprocal. These agreements bind and benefit not only the original parties to the agreement, but also their successors and interests. Again, there's a dichotomy here. There are two major types of private agreements, private land use agreements that we typically recognize in the United States. The first is a real covenant, and the second type that we recognize is an equitable servitude. Everything in this discussion hinges on what happens if the agreement is breached. In the case of a real covenant, if the agreement is breached, the agreed party seeks money damages in the form of a lawsuit. On the other hand, in the case of an equitable servitude, if the agreement is breached, the party goes to the court and seeks to enforce an injunction or lien or other types of equitable remedies. So everything hinges on the type of violation and the remedy that you seek. That's the difference and the distinction between these two. Again, just to recap briefly, if you seek money damages as a litigant, you are enforcing a real covenant. On the other hand, if you seek equitable relief in the form of an injunction or imposition of a lien or other equitable remedies, then you are looking at enforcing an equitable servitude. Let's just go back a little bit in history. Why is there a distinction between these two? One that is enforced with money damages and one that you use or seek equitable remedies with. In the old days, courts were really fearful of imposing undue burdens and restrictions on property that would make property unalienable over the course of time. So as these agreements took hold and took root, courts of law were really jealous about fettering the ability of a person to sell their property. So they stopped enforcing real covenants and made it really hard and increasingly difficult to come to the court to seek damages when these agreements or these promises were breached by parties. So what did people do in old England? They turned to the chancellor, to the equity courts, and they got a more receptive welcome from the equity courts. So that's why we have this dichotomy in American law going all the way back to English law between real covenants and equitable servitudes, because the chancellor was more apt and more willing to enforce promises through the grant of equitable relief in the form of injunctions. So that's why there's this distinction. All right, so everything hinges on the type of remedy that you're seeking: money damages versus equitable relief or other equitable remedies. Equitable servitudes, again, which I said are the focus of equitable relief and injunctions. Let me just give you some examples. How do these things kind of play themselves out? For example, a person might decide that they're going to give someone the right to enforce a restriction on the use of their land. Typically, I could use my land as I see fit, unfettered, right? But for example, I might say or make a promise to someone: if you sell me this piece of land, I will only use it to build a residential structure. So again, I'm taking away my ability to freely use this property as I would see fit. The imposition of the promise might be that promise that I build only a residential property or a home rather than use the property commercially or industrially, like I might otherwise be able to do. We see these very commonly in the United States. For example, restrictions that say that you can only build a residential property. Another type or category of restrictions that we see really commonly are restrictions on the size of the residential home that you can build on a piece of property. Oftentimes you might see a restriction that someone can build only a home that's 2,000 square feet of livable space or 2,500 square feet of livable space or more on a particular property. And the whole idea behind this is that you don't get properties that are not in character with a particular development or neighborhood. And again, it goes back to the original purpose, maximizing value for everyone or every property that's benefited or burdened by this covenant or by this promise. So that's what it all comes down to. A person may also make a promise that they're going to be required to do something or to perform an act on their land. One of the great examples goes back to a British case, the Toke versus Moxhay case, where someone sold the original property that they owned that ended up becoming Leicester Square. In the middle of the property that they sold and subdivided for residential purposes, they placed a private park and garden with an equestrian statue. And when they sold it to a new owner, that new owner took on a promise that they were going to maintain the equestrian statue and the gardens that they bought from the original owner at their expense. So that's a classic example. Maybe someone builds a monument or a mausoleum or a memorial on the property that they end up selling to you, and they sell it to you, and you make a promise that you're going to maintain at your own expense that memorial or that mausoleum or that monument. If that's the case, you have to do so. You're bound by that promise. Another example that we often see might be a promise that you're going to pay money to someone for the upkeep of a specified facility or a portion of a piece of property. Just to give you clear examples of what this looks like, well, if you have a homeowners association or a condominium association, or you own a co-op apartment, sometimes you have to pay a monthly fee, and that fee is used to maintain common facilities or common elements of that property. For example, that could be, the clubhouse or the gym or the party center at your homeowners association or your condo association. So that promise is a binding promise to pay money. So that's what this hinges on. And again, as I said in the beginning of the discussion, everything hinges upon the remedy or the relief that you seek. Are you seeking money damages? If you're seeking money damages for the violation or breach of one of these promises, then we have a real covenant. If you're seeking equitable relief or remedies, then we have an equitable servitude. And as a final matter, I just want to give you really clearly what these elements are and what they consist of legally. As the final thing that we're going to talk about today, I just want to share with you the 4 traditional legal elements that courts look for when they're trying to determine whether or not someone has an enforceable real covenant. Each one of these 4 elements must be proven and met for the litigant, for example, the plaintiff, to prevail. Number 1, because this is an interest affecting real property, it is subject to the statute of frauds. The first element is that, number 1, the real covenant must be in writing. The agreement must be in writing. That's the first element. The second element is that the parties must intend to bind their future successors. Not only am I binding myself, but I'm also binding those who might buy the property from me in the future or who might come behind me once I'm no longer on the scene. So number 2, the parties must intend to bind future successors. And then number 3, the promise must touch and concern the land. And then finally, fourthly, there has to be horizontal and vertical privity between the parties. Well, what is horizontal and what is vertical privity? Well, horizontal privity is the contractual connection between the original parties. Let's say the original grantor who decides to sell the parcel or the property to B. A might be the original grantor and B might be the original grantee. In that sort of scenario, side to side, we have horizontal privity. And let's say later on, party B decides that they're going to sell the property to party C. If that were the case, then we have vertical privity. Vertical privity is up and down, and it might manifest itself when the property is sold, or rights might be obtained later on in that same piece of property by someone further down the line. So horizontal and vertical privity are necessary to enforce a real covenant. And let me just recap again and make it really crystal clear. The 4 elements that are necessary for the enforcement of a real covenant are: number 1, the agreement must be in writing. Number 2, the parties must intend to bind their future successors. Number 3, the promise must touch and concern the land. And finally, number 4, there has to be horizontal and vertical privity that exists between the parties. What are the elements, finally, for a real covenant? What are the elements, finally, for an equitable servitude? There are 3 elements that are necessary to enforce injunctive relief or equitable relief to obtain mercy from a court of equity when you go into the court to try to enforce an equitable servitude. The first element is intent. The parties must intend that the promise be binding. So intent is necessary. Number 2, the promise must touch and concern the land. And thirdly and finally, there must be notice. So just to recap again, the 3 elements that are necessary to enforce an equitable servitude are: number 1, intent. Number 2, the promise must touch and concern the land. And thirdly, there must be notice. Horizontal and vertical privity, as you can see, are not required elements for the burden or the benefit to run for an equitable servitude. So those are elements that are not necessary to enforce an equitable servitude. Again, they are important to enforce a real covenant, but they are not necessary. Horizontal and vertical privity, that is, are not necessary to enforce an equitable servitude. These are matters that are really, really confusing for practicing lawyers and have been confusing for generations of law students. I hope that today you find this video to be helpful and that it gives you a little bit of insight into the differences, the true technical differences between real covenants and equitable servitudes. Remember, just to recap, these are private land use agreements, private promises between parties that bind those parties and their successors. And ideally, the intent is to maximize the value of property over the course of time by making it beneficial for all parties to develop the property in a way that benefits everyone. And remember, it all comes down to enforcement and the type of remedy that you seek. If you want damages, if someone breaches a promise and you're seeking money damages, you have a real covenant. If you're seeking injunctive relief or other equitable remedies like the imposition of a lien if someone doesn't pay their homeowners association fees or their condominium association fees, then you have an equitable servitude. Again, I hope these videos were helpful. Best of luck. Thank you for tuning in and listening today.